One of Ferguson's primary objections centers on the amendment to the Criminal Procedure Code, which seeks to remove the discretion of a magistrate to grant bail to offenders under the Firearms Act. This proposed change through the Criminal Procedure Code Amendment Bill comes in response to the escalating incidents of gun violence in the country.
One recognizes the need that you have to find ways and means of addressing these shootings, the prevalence of firearms offenses, and yes, so there's no issue with that. But one has to be careful of not doing a knee-jerk response to these things, plasters on sores, and run and remove the discretion of a magistrate to grant bail. Most of our magistrates are seasoned judicial officers who, over the years, many years, have granted bail, heard bail applications for everything save for treason and murder.
Noting that an offender is considered innocent until proven guilty, the King's Counsel said, with the high volume of matters currently before the High Court, the amendment could exacerbate existing delays and further strain judicial resources.
With the number of matters before the High Court, you need about 4 judges full-time to really clear that backlog. And now, for offenses under the Firearms Act, you are removing that authority of the magistrate to grant bail and placing it in the hands of already overloaded judges. A magistrate is a judicial officer, and there is really no reason to remove from the jurisdiction of the magistrate. In fact, what should be happening is the adding of many offenses triable before the magistrate instead of clogging up the High Court, where all these things have to be tried before judge and jury.
Ferguson also criticized proposed changes that would eliminate the magistrate's discretion in sentencing for firearm offenses.
So whereas before, on summary conviction, you had people liable to a fine of $4,000 and 2 years in prison, a maximum of 5 years, or a maximum fine of $20,000. The proposal is to remove the fines altogether, significantly increase the sentences, more than 100% in some cases, so the minimum, and introduce a minimum mandatory sentence of 10 years for possession of a firearm. 10 years in the magistrate's court and a maximum of 20 years. Remove the element of the fine and impose a prison sentence with, if you are found guilty, the least sentence you can get is 10 years. No. And in the case of the High Court, to tie the hands of the High Court and have it, if it's an indictable charge, a minimum of 20 years and a maximum of 40 years.
He called for a more measured approach, inclusive of public consultation, urging the government to thoroughly evaluate the potential consequences of these legislative changes. The debate over these amendments is likely to be intense as it goes before Parliament tomorrow, Tuesday, and Wednesday, with stakeholders from various sectors weighing in on the best approach to address gun violence while ensuring a just and efficient judicial process. Reporting for GBN News, I'm Nisha Paul.